Justice Bryer, with whom Justice Ginsburg and Justice Sotomayor joined, dissenting. In my view, Justice Stevens has demonstrated that the 14th Amendment's guarantee of substantive due process does not include general right to keep and bear firearms for purposes of private self-defense. As he argues, the framers did not write the Second Amendment with this objective in view. See ante at 4144, dissenting opinion. Unlike other forms of substantive liberty, the carrying of arms for that purpose often puts others' lives at risk. See ante at 3537, and the use of arms for private self-defense does not warrant federal constitutional protection from state regulation. See ante at 4451. The court, however, does not expressly rest its opinion upon substantive due process concerns. Rather, it directs its attention to this court's incorporation of precedent and asks whether the Second Amendment right to private self-defense is fundamental so that it applies to the states through the 14th Amendment. See ante at 1119. I shall therefore separately consider the question of incorporation. I can find nothing in the Second Amendment's text, history, or underlying rationale that could warrant characterizing it as fundamental insofar as it seeks to protect the keeping and bearing of arms for private self-defense purposes, nor can I find any justification for interpreting the Constitution as transferring ultimate regulatory authority over the private uses of firearms from democratically elected legislatures to courts or from the state, the federal government. I therefore conclude that the 14th Amendment does not incorporate the Second Amendment's right to keep and bear arms, and I consequently dissent. The Second Amendment says, well-regulated militia being necessary to the security of free state, the right of the people to keep and bear arms shall not be infringed. 2 years ago, in District of Columbia v. Heller 554 U.S. 2008, the court rejected the pre-existing judicial consensus that the Second Amendment was primarily concerned with the need to maintain well-regulated militia. CID at Stevens J. Dissenting slip-op at 23 and N2 3845 United States v. Miller 307 U.S. 174 178 1939. Although the court acknowledged that the threat that the new federal government would destroy the citizens' militia by taking away their arms was the reason that right was codified in written constitution, the court asserted that individual self-defense was the central component of the right itself. Heller Super at slip-op at 26 first emphasis added. The court went on to hold that the Second Amendment restricted Congress' power to regulate handguns used for self-defense, and the court found unconstitutional the District of Columbia's ban on the possession of handguns in the home. ID at slip-op at 6-4. The court based its conclusions almost exclusively upon its reading of history, but the relevant history in Heller was far from clear. 4 dissenting justices disagreed with the majority's historical analysis, and subsequent scholarly writing reveals why disputed history provides treacherous ground on which to build decisions written by judges who are not expert at history. Since Heller, historians, scholars, and judges have continued to express the view that the court's historical account was flawed. C.E. G. Koenig, Why the Second Amendment Has a Preamble, Original Public Meaning and the Political Culture of Written Constitutions in Revolutionary America, 50 Sikualeole Everin 1295, 2009. Finkelman, It Really Was About a Well-Regulated Militia, 59 Syracuse L. Everin 267, 2008. P. Charles, The Second Amendment, The Intent and Its Interpretation by the States and the Supreme Court, 2009. Merkel, The District of Columbia v. Heller and Antonin Scalia's Perverse Sense of Originalism, 13 Lewis and Clark L. Everin 349, 2009. A Casus Genish, Originalism and Digital Age, An Inquiry into the Right to Bear Arms, 29J. Early Republic 585, 2009. A Cornell. Ain't George Tucker's Lecture Notes, The Second Amendment, An Originalist Methodology, 103 NWL. Everin 1541, 2009. Posner in Defense of Looseness, The Supreme Court in Gun Control, New Republic Aug. 27, 2008, pp. 3235. See also Epstein, Structural Interpretation of the Second Amendment, Why Heller is Probably Wrong on Originalist Grounds, 59 Syracuse L. Everin 171, 2008. Consider as an example of these critiques an amici brief filed in this case by historians who specialize in the study of the English Civil Wars. They tell us that Heller misunderstood key historical point. See brief for English early American historians as amici curiae hereinafter English historians brief, filed by 21 professors at leading universities in the United States, Kingdom, and Australia. Heller's conclusion that Individual self-defense was of the central component of the Second Amendment's right to keep and bear arms rested upon its view that the amendment codified pre-existing right that had nothing whatever to do with service in militia. 554 U.S. that slip up at 26/1920. That view in turn rested in significant part upon Blackstone having described the right as the right of having and using arms for self-preservation and defense, which reflected the provision in the English Declaration of Right of 1689 that gave the king's Protestant subjects the right to have arms for their defense suitable to their conditions and as allowed by law. The D at slip up at 1920, quoting 1W. Blackstone, Commentaries on the Laws of England, 140 1765, hereinafter Blackstone, and 1W, NMC2, SS in 3 Stat, at large 441, 1689. The framers said the majority understood that right as permitting citizen to repel force by force when the intervention of society in his behalf may be late to prevent an injury. 554 U.S. at slip up at 21, quoting George Tucker, 1 Blackstone's Commentaries 145, 146, and 42, 1803. The historians now tell us, however, that the right to which Blackstone referred had not nothing but everything to do with the militia, as properly understood at the time of the English Civil Wars. The historians claim the right to bear arms ensured that Parliament had the power to arm citizenry, to defend the realm in the case of foreign enemy, and to secure the right of self-preservation or self-defense should the sovereign usurp the English Constitution. The English Historians Brief 3, 813, 23, 24, emphasis added. Thus the Declaration of Right says that private persons can possess guns only, as allowed by law. CID at 2024. Moreover, when Blackstone referred to the right of having and using arms for self-preservation and defense, he was referring to the right of the people to take part in the militia to defend their political liberties, and to the right of Parliament, which represented the people, to raise militia even when the king sought to deny it that power. ID at 424-27, emphasis added, quoting 1 Blackstone 140, nor can the historian find any convincing reason to believe that the framers had something different in mind than what Blackstone himself meant. Compare Heller, Supra, at slip up, at 2122, with English Historians Brief 2840. The historians concede that at least one historian takes different position, CID, at 7, but the court, they imply, would lose poll taken among professional historians of this period, say by vote of 8 to if history alone is what matters. Why would the court not now reconsider Heller in light of these more recently published historical views? See League in Creative Leather Products, Inc., v. PSSKS, Inc., 551 U.S., 877, 923, 924, 2007. Bryer, J. Dissenting, noting that stare decisis interests are at their lowest with respect to recent and erroneous constitutional decisions that create unworkable legal regimes. Citizens United v. Federal Election Command 558 U.S. 2010, slip-up, at 47, listing similar factors. See also Wallace v. Jaffrey 472 U.S. 38, 99, 1985, Rehnquist, J. Dissenting, stare decisis may bind courts as to matters of law, but they cannot bind them as to matters of history. At the least, where Heller's historical foundations are so uncertain, why extend its applicability? I aim in referring to this history is to illustrate the reefs and shoals that lie in wait for those non-expert judges who place virtually determinative weight upon historical considerations. In my own view, the court should not look to history alone but to other factors as well, above all in cases where the history is so unclear that the experts themselves strongly disagree. It should, for example, consider the basic values that underlie a constitutional provision and their contemporary significance, and it should examine as well the relevant consequences and practical justifications that might or might not warrant removing an important question from the democratic decision-making process. Cianti at 1620, Stevens, J. Dissenting, discussing shortcomings of an exclusively historical approach. In my view, taking Heller as a given, the 14th Amendment does not incorporate the Second Amendment right to keep and bear arms for purposes of private self-defense. Under this court's precedents, to incorporate the private self-defense right, the majority must show that the right is e.g. fundamental to the American scheme of justice. Duncan v. Louisiana, 391 U.S. 145, 149, 1968. See Ibid, N. 14. See also ante at 44, plurality opinion, finding that the right is fundamental and therefore incorporated, and this it fails to do. The majority here like that, and Heller relies almost exclusively upon history to make the necessary showing. Ante at 2033. But to do so for incorporation purposes is both wrong and dangerous. As Justice Stevens points out, our society has historically made mistakes. For example, when considering certain 18th and 19th century property rights to be fundamental, ante at 19 dissenting opinion. And in the incorporation context, as elsewhere, history often is unclear about the answers. See Part I supra of Promen Infra. Accordingly, this court, in considering an incorporation question, has never stated that the historical status of a right is the only relevant consideration. Rather, the court has either explicitly or implicitly made clear in its opinions that the right in question has remained fundamental over time. C.E. G. Padaka v. Oregon 406 U. S. 404, 410, 1972, plurality opinion stating that the incorporation inquiry must focus upon the function served by the right in question in contemporary society, emphasis added. Duncan v. Louisiana 391 U.S. 145, 154, 1968, noting that the right in question continues to receive strong support. Klopfer v. North Carolina 386 U.S. 213, 226, 1967, same. And indeed, neither of the parties before us in this case has asked us to employ the majority's history-constrained approach. See brief for petitioners 6769, arguing for incorporation based on trends in contemporary support for the right. A brief for respondents City of Chicago et al. 2331, herein after municipal respondents look current state practices with respect to the right. I thus think it proper above all, where history provides no clear answer, to look to other factors in considering where the right is sufficiently fundamental to remove it from the political process in every state. That would include among those factors the nature of the right, any contemporary disagreement about whether the right is fundamental, the extent to which incorporation will further other perhaps more basic constitutional aims, and the extent to which incorporation will advance or hinder the Constitution's structural aims, including its division of powers among different governmental institutions and the people as well. Is incorporation needed, for example, to further the Constitution's effort to ensure that the government treats each individual with equal respect? Will it help maintain the democratic form of government that the Constitution foresees? In word, will incorporation prove consistent or inconsistent with the Constitution's efforts to create governmental institutions well suited to the carrying out of its constitutional promises? Finally, I would take account of the framers' basic reason for believing the court ought to have the power of judicial review. Alexander Hamilton feared granting that power to Congress alone, for he feared that Congress acting as judges would not overturn as unconstitutional popular statute that it had recently enacted as legislators. The Federalist No. 78 p. 405 g. Carey and J. McCullan eds. 2001 a. Hamilton, this independence of the judges is equally requisite to guard the Constitution and the rights of individuals from acts of those ill humors which can at times lead to serious oppressions of the minor part in the community. Judges, he thought, may find it easier to resist popular pressure to suppress the basic rights of an unpopular minority. See United States v. Caroline Products Company 304 U.S. 144, 152, n. 4, 1938. That being so, it makes sense to ask whether that particular comparative judicial advantage is relevant to the case at hand. C. E. G. J. Ely Democracy and Distrust 1980. B. How do these considerations apply here? For one thing, I would apply them only to the private self-defense right directly at issue. After all, the amendment's militia-related purpose is primarily to protect states from federal regulation, not to protect individuals from militia-related regulation. Heller 554 U.S. at Slip-Op at 26. See also Miller 307 U.S. at 178. Moreover, the Civil War amendments, the electoral process, the courts, and numerous other institutions today help to safeguard the states and the people from any serious threat of federal tyranny. How are state militias additionally necessary? It is difficult to see how right that, as the majority concedes, has largely faded as popular concern could possibly be so fundamental that it would warrant incorporation through the 14th Amendment, ante at 22. Hence, the incorporation of the Second Amendment cannot be based on the militia-related aspect of what Heller found to be more extensive Second Amendment rights. For another thing, as Heller concedes, the private self-defense right that the court would incorporate has nothing to do with The reason the framers codified the right to keep and bear arms, the written Constitution, 554 U.S. that slip up at 26, emphasis added. Heller immediately adds that the self-defense right was nonetheless the central component of the right. Ibid, in my view, this is the historical equivalent of claim that water runs uphill, see Part I, supra, but taking it as valid, the framers' basic reasons for including language in the Constitution would nonetheless seem more pertinent in deciding about the contemporary importance of right than the particular scope. 17th or 18th century listeners would have then assigned to the words they used, and examination of the framers' motivation tells us they did not think the private armed self-defense right was of paramount importance. See Ammer, The Bill of Rights, Constitution, 100 Yale J. 1131, 1164, 1991, to see the Second Amendment as primarily concerned with an individual right to hunt or protect one's home would be like viewing the heart of the speech and assembly clauses as the right of persons to meet to play bridge. See also A. G. Rakoff, The Second Amendment, the highest stage of originalism, 76 Chai. Cantal, Everend 103, 127, 128, 2000, a brief for historians on early American legal, constitutional, and Pennsylvania history as Amici Curie 2233. Further, there is no popular consensus that the private self-defense right described in Heller is fundamental. The plurality suggests that 2 Amici briefs filed in the case show such consensus, see ante at 4240. But of course numerous Amici briefs have been filed opposing incorporation as well. Moreover, every state regulates firearms extensively and public opinion is sharply divided on the appropriate level of regulation. Much of this disagreement rests upon empirical considerations. One side believes the right essential to protect the lives of those attacked in the home. The other side believes it essential to regulate the right in order to protect the life. Others attacked with guns. It seems unlikely that definitive evidence will develop one way or the other. An appropriate level of firearm regulation has thus long been and continues to be a hotly contested matter of political debate. C. E. G. Siegel, Dead or Alive. Originalism as Popular Constitutionalism in Heller, 122 Harv. L. Everend 191, 201, 246, 2008. Numerous sources, supporting arguments, and data near Roman to can be found in the Appendix Infra. Moreover, there is no reason here to believe that incorporation of the private self-defense right will further any other or broader constitutional objective. We are aware of no argument that gun control regulations target or are passed with a purpose, targeting discrete and insular minorities. Caroline Products Company, Super at 153 and 4 CEG, Ante at 4951 Stevens J. Dissenting. Nor will incorporation help to assure equal respect for individuals. Unlike the First Amendment's rights of free speech, free press, assembly, and petition, the private self-defense right does not comprise necessary part of the democratic process that the Constitution seeks to establish. C.E.G. Whitney v. California, 274 U.S. 357, 377, 1927, Brandeis, J. Concurring. Unlike the First Amendment's religious protections, the Fourth Amendment's protection against unreasonable searches and seizures, the Fifth and Sixth Amendment's insistence upon fair criminal procedure, and the Eighth Amendment's protection against cruel and unusual punishments, the private self-defense right does not significantly seek to protect individuals who might otherwise suffer unfair or inhumane treatment at the hands of majority. Unlike the protections offered by many of these same amendments, it does not involve matters as to which judges possess a comparative expertise by virtue of their close familiarity with the justice system and its operation, and unlike the Fifth Amendment's insistence on just compensation, it does not involve matter where majority might unfairly seize for itself property belonging to minority. Finally, incorporation of the right will work significant disruption in the constitutional allocation of decision-making authority, thereby interfering with the Constitution's ability to further its objectives. First, on any reasonable accounting, the incorporation of the right recognized in Heller would amount to significant incursion on traditional and important area of state concern, altering the constitutional relationship between the states and the federal government. Private gun regulation is the quintessential exercise. States, police power, the power to protect the lives, limbs, health, comfort, and quiet of all persons, and the protection of all property within the state, by enacting all kinds of restraints and burdens on both persons and property. Slaughterhouse cases, 16 Wall, 3662, 1873, internal quotation marks omitted. The court has long recognized that the Constitution grants the states special authority to enact laws pursuant to this power. C. E. G. Medtronic, Inc. v. Lower 518 U.S. 470-475, 1996, noting that states have great latitude to use their police powers, internal quotation marks omitted, a Metropolitan Life Ends, Company v. Massachusetts, 471 U.S. 724, 756, 1985. Decade ago, we wrote that there is no better example of the police power than of the suppression of violent crime. United States v. Morrison, 529 U.S. 598, 618, 2000, in examples in which the court has deferred to state legislative judgments in respect to the exercise of the police power or legion. C. E. G. Gonzalez v. Oregon, 546 U.S. 243, 270, 2006, assisted suicide. Washington v. Glucksberg, 521 U.S. 702, 721, 1997, same. Berman v. Parker, 348 U.S. 26, 32, 1954. We deal, in other words, with what traditionally has been known as the police power. An attempt to define its reach or trace its outer limits is fruitless. Second, determining the constitutionality of particular state gun law requires finding answers to complex empirically based questions of kind that legislatures are better able than courts to make. C. E. G. Los Angeles v. Alameda Books, Inc. 535 U.S. 425, 440, 2002, plurality opinion. Turner Broadcasting System, Inc. v. FCC 520 U.S. 180, 195, 196, 1997, and it may require this kind of analysis in virtually every case. Government regulation of the right to bear arms normally embodies judgment that the regulation will help save lives. The determination whether gun regulation is constitutional would thus almost always require the weighing of the constitutional right to bear arms against the primary concern. Every government concern for the safety and indeed the lives of its citizens. United States v. Salerno, 481 U.S. 739, 755, 1987. With respect to other incorporated rights, this sort of inquiry is sometimes present. C. E. G. Brandenburg v. Ohio, 395 U.S. 444, 447, 1969. Per curiam free speech. Sherbert v. Werner, 374 U.S. 398, 403, 1963. Religion. Brigham City v. Stewart, 547 U.S. 398, 403, 404, 2006. Fourth Amendment. In New York v. Quarles, 467 U.S. 649, 655, 1984. Fifth Amendment. Salerno Supra at 755 bail. But here, this inquiry calling for the fine-tuning of protective rules is likely to be part of a daily judicial diet. Given the competing interests, courts will have to try to answer empirical questions of a particularly difficult kind. Suppose, for example, that after a gun regulation's adoption, the murder rate went up. Without the gun regulation, would the murder rate have risen even faster? How is this conclusion affected by the local recession which has left numerous people unemployed? What about budget cuts that led to downsizing of the police force? How effective was that police force to begin with? And did the regulation simply take guns from those who use them for lawful purposes without affecting their possession by criminals? Consider, too, that countless gun regulations of many shapes and sizes are in place in every state and in many local communities. Does the right to possess weapons for self-defense extend outside the home? To the car? To work? What sort of guns are necessary for self-defense? Handguns? Rifles? Semi-automatic weapons? When is gun semi-automatic? Where are different kinds of weapons likely needed? Does time of day matter? Does the presence of child in the house matter? Does the presence of convicted felon in the house matter? Do police need special rules permitting pat-downs designed to find guns? When do registration requirements become severe to the point that they amount to an unconstitutional ban? Who can possess guns and of what kind? Aliens? Prior drug offenders? Prior alcohol abusers? How would the right interact with state or local government's ability to take special measures during, say, national security emergencies? As the questions suggest, state and the local gun regulation can become highly complex, and these are only few uncertainties that quickly come to mind. Caperton v. T. Massey Coal Company, 556 S. 2009. Roberts, C. J. Dissenting slip-up at 10. The difficulty of finding answers to these questions is exceeded only by the importance of doing so. Firearms cause well over 60,000 deaths and injuries in the United States each year. Those who live in urban areas, police officers, women, and children all may be particularly at risk, and gun regulation may save their lives. Some experts have calculated, example, that Chicago's handgun ban has saved several hundred lives, perhaps close to 1,000 since it was enacted in 1983. Other experts argue that stringent gun regulations can help protect police officers operating on the front lines against gun violence, have reduced homicide rates in Washington, D.C., and Baltimore, and have helped to lower New York's crime and homicide rates. At the same time, the opponents of regulation cast doubt on these studies and who is right. Finding out may require interpreting studies that are only indirectly related to particular regulatory statute, say one banning handguns in the home. Suppose studies find more accidents and suicides where there is handgun in the home than where there is long gun in the home or no gun at all. To what extent do such studies justify ban? What if opponents of the ban put forth counter studies? Answering such questions, judges cannot simply refer to judicial homilies, such as Blackstone's 18th century perception that man's home is his castle. See 4 Blackstone 223. Nor can the plurality so simply reject, by mere assertion, the fact that incorporation will require judges to assess the costs and benefits of firearms restrictions. And he, at 44. How can the court assess the strength of the government's regulatory interests without addressing issues of empirical fact? How can the court determine if regulation is appropriately tailored without considering its impact? And how can the court determine if there are less restrictive alternatives without considering what will happen if those alternatives are implemented? Perhaps the court could lessen the difficulty of the mission it has created for itself by adopting jurisprudential approach similar to the many state courts that administer state constitutional right to bear arms. See infra at 1920 describing state approaches, but the court has not yet done so. Cf. Heller, 544 U.S. at Slip-Op, at 5764, rejecting an interest balancing approach similar to that employed by the states, and T at 44 plurality opinion. Rather, the court has haphazardly created few simple rules, such as that it will not touch prohibitions on the possession of firearms by felons and mentally ill, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. 544 U.S. that Slip-Op at 5455, and T at 39, plurality opinion. But why these rules and not others? Does the court know that these regulations are justified by some special gun-related risk of death? In fact, the court does not know. It has simply invented rules that sound sensible without being able to explain why or how Chicago's handgun ban is different. The fact is that judges do not know the answers to the kinds of empirically based questions that will often determine the need for particular forms of gun regulation, nor do they have readily available tools for finding and evaluating the technical material submitted by others. District Attorney's Office for 3rd Judicial Dist. V. Osborne, 557 U.S. 2009, Slip-Op at 21. See also Turner Broadcasting, 520 U.S. at 195-196. Judges cannot easily make empirically based predictions. They have no way to gather and evaluate the data required to see if such predictions are accurate, and the nature of litigation and concerns about stare decisis further make it difficult for judges to change course if predictions prove inaccurate. Nor can judges rely upon local community views and values when reaching judgments. Circumstances where prediction is difficult because the basic facts are unclear or unknown. At the same time, there is no institutional need to send judges off on this mission almost impossible. Legislators are able to amass the stuff of actual experience and call conclusions from it. United States v. Gainey, 380 U.S. 6367, 1965. They are far better suited than judges to uncover facts and to understand their relevance in the legislators, unlike Article Rome, judges can be held democratically responsible for their empirically based and value-laden conclusions. We have thus repeatedly affirmed our preference for legislative, not judicial solutions to this kind of problem. C.E. G. Patsy v. Board of Regents of Flaw, 457 U.S. 496, 513, 1982. Just as we have repeatedly affirmed the Constitution's preference for democratic solutions legislated by those whom the people elect. In New State Ice Umpany v. Liebman, 285 U.S. 262, 310, 311, 1932, Justice Brandeis stated in Dissent, Some people assert that our present plight is due, in part, to the limitations set by courts upon experimentation in the fields of social and economic science, and to the discouragement to which proposals for betterment there have been subjected. Otherwise, there must be power in the states and the nation to remold through experimenting our economic practices and institutions to meet changing social and economic needs. I cannot believe that the framers of the 14th Amendment, or the states which ratified it, intended to deprive us of the power to correct the social problems we face. There are 50 state legislatures. The fact that this court may already have refused to take this wise advice with respect to Congress in Heller is no reason to make matters worse here. Third, the ability of states to reflect local preferences and conditions, both key virtues of federalism. As particular importance, the incidence of gun ownership varies substantially, as between crowded cities and uncongested rural communities, as well as among the different geographic regions of the country. Thus, approximately 60% of adults who live in the relatively sparsely populated western states of Alaska, Montana, and Wyoming report that their household keeps gun, while fewer than 15% of adults in the densely populated eastern state, Rhode Island, New Jersey, and Massachusetts say the same. The nature of gun violence also varies, as between rural communities and cities. Urban centers face significantly greater levels of firearm crime and homicide, while rural communities have proportionately greater problems with non-homicide gun deaths, such as suicides and accidents. And idiosyncratic local factors can lead to two cities finding themselves in dramatically different circumstances. For example, in 2008, a murder rate was 40 times higher in New Orleans than it was in Lincoln, Nebraska. It is thus unsurprising that states and local communities have historically differed about the need for gun regulation as well as about its proper level. Nor is it surprising that, primarily and historically, the law treated the exercise of police powers, including gun control, as matters of local concern. Medtronic 518 U.S. at 475, internal quotation marks omitted. Fourth, although incorporation of any right removes decisions from the democratic process, the incorporation of this particular right does so without strong offsetting justification, as the example of Oak Park's handgun ban helps to show. See Oak Park Yale, Municipal Code SS21, 1995. Oak Park decided to ban handguns in 1983 after local attorney was shot to death with handgun that his assailant had smuggled into courtroom and blanket. Brief for Oak Park Citizens Committee for Handgun Control as Amicus Curiae 121 hereinafter. Oak Park Brief. Citizens Committee spent months gathering information about handguns, ID, at 21. It secured 6,000 signatures from community residents in support of ID at 2122, and the village board enacted ban into law ID at 22. Subsequently, at the urging of ban opponents, the board held community referendum on the matter. IBID, the Citizens Committee argued strongly in favor of the ban ID at 2223. It pointed out that most guns owned in Oak Park were handguns and that handguns were misused more often than citizens used them in self-defense. ID at 23. The ban opponents argued just as strongly to the contrary. IBID. The public decided to keep the ban by a vote of 8,031 to 6,368. IBID. And since that time, Oak Park now tells us crime has decreased and the community has seen no accidental handgun deaths. ID at 2. Given the empirical and local value-laden nature of the questions that lie at the heart of the issue, why in a nation whose constitution foresees democratic decision-making is it so fundamental a matter as to require taking that power from the people? What is it here that the people did not know? What is it that a judge knows better? In sum, the police power, the superiority of legislative decision-making, the need for local decision-making, the comparative desirability of democratic decision-making, the lack of a manageable judicial standard, and the life-threatening harm that may flow from striking down regulations all argue against incorporation. Where the incorporation of other rights has been at issue, some of these problems have arisen, but in this instance, these problems are present all at the same time, and all are likely to be present in most, perhaps nearly all, of the cases in which the constitutionality of a gun regulation is at issue. At the same time, the important factors that favor incorporation in other instances, e.g., the protection of broader constitutional objectives, are not present here. The upshot is that all factors militate against incorporation, with the possible exception of historic factors. I must then return to history. The plurality, in seeking to justify incorporation, asks whether the interests the Second Amendment protects are deeply rooted in this nation's history and tradition. Ante at 19, quoting Glucksberg 521 U.S. at 721, internal quotation marks omitted. It looks to selected portions of the nation's history for the answer, and it finds an affirmative reply. As I have made clear, I do not believe history is the only pertinent consideration, nor would I read history as broadly as the majority does, in particular since we here are evaluating more particular right, namely the right to bear arms for purposes of private self-defense. General historical references to the right to keep and bear arms are always helpful. Depending upon context, early historical sources may mean to refer to militia-based right, matter of considerable importance 200 years ago, which has, as the majority points out, largely faded as popular concern. Ante at 22. There is no reason to believe that matters of such little contemporary importance should play a significant role in answering the incorporation question. See Apodaca 406 U.S. at 410 Incorporation. Inquiry must focus upon the function served by the right in question in contemporary society. Wolfe, Colorado 338 U.S. 25-27 1949. Incorporation must take into account the movements of free society and a gradual and empiric process of inclusion and exclusion. Internal quotation marks omitted. EF U.S. Const. Art. ISS prohibiting federal office holders from accepting title of any kind whatever from a foreign state, presumably matter of considerable importance 200 years ago. That said, I can find much in the historical record that shows that some Americans in some places at certain times thought it important to keep and bear arms for private self-defense. For instance, the reader will see that many states have constitutional provisions protecting possession, but as far as I can tell, those provisions typically do no more than guarantee that a gun regulation will be a reasonable police power regulation. See Winkler scrutinizing the Second Amendment, 105 Mitch L. Everin 683, 686, 716, 717, 2007. The courts of every state to consider the question apply deferential reasonable regulation standard. Hereinafter Winkler scrutinizing. See also ID at 716, 717, explaining the difference between that standard and ordinary rational basis review. It is thus altogether unclear whether such provisions would prohibit cities such as Chicago from enacting laws such as the law before us banning handguns. CID at 723. The majority, however, would incorporate right that is likely inconsistent with Chicago's law, and the majority would almost certainly strike down that law. Cf. Heller 554 U.S. at Slip-Up at 5764, striking down the District of Columbia's handgun ban. Thus, the specific question before us is not whether there are references to the right to bear arms for self-defense throughout this nation's history. Of course there are, or even whether the court should incorporate simple constitutional requirement that firearms regulations not unreasonably burden the right to keep and bear arms, but rather whether there is consensus. So substantial private self-defense right as the one described in Heller applies to the states. C.E.G. Glucksberg Supra at 721, requiring careful description of the right at issue when deciding whether it is deeply rooted in this nation's history and tradition. Internal quotation marks omitted. On this question, the reader will have to make up his or her own mind about the historical record that I describe in part below. In my view, that record is insufficient to say that the right to bear arms for private self-defense as explicated by Heller is fundamental in the sense relevant to the incorporation inquiry. As the evidence below shows, states and localities have consistently enacted firearms regulations, including regulations similar to those at issue here throughout our nation's history. Courts have repeatedly upheld such regulations, and it is, at the very least, possible, and perhaps likely, that incorporation will impose on every, or nearly every, state different right to bear arms than they currently recognize right that threatens to destabilize settled state legal principles. Cf. 554 U.S. at Slip-Up at 5764, rejecting an interest balancing approach similar to that employed by the states. I thus cannot find a historical consensus with respect to whether the right described by Heller is fundamental as our incorporation cases use that term, nor can I find sufficient historical support for the majority's conclusion that that right is deeply rooted in this nation's history and tradition. Instead, I find no more than ambiguity and uncertainty that perhaps even expert historians would find difficult to penetrate. And historical record is so ambiguous cannot itself provide an adequate basis for incorporating private right of self-defense and applying it against the states. The 18th century, the opinions in Heller collect much of the relevant 18th century evidence. See 554 U.S. at Slip Op at 532 D. at Stevens J. Dissenting Slip Op at 531 D. at Bryer J. Dissenting Slip Op at 47. In respect to the relevant question, deeply rooted nature of right to keep and bear arms for purposes of private self-defense, that evidence is inconclusive, particularly when augmented as follows. First, as I have noted earlier in this opinion, and Justice Stevens argued in Dissent, a history discussed in Heller shows that the Second Amendment was enacted primarily for the purpose of protecting militia-related rights. See Supra at 4 Heller Supra. Slip Op at 531. Many of the scholars and historians who have written on the subject apparently agree. See Supra at 2.5. Second, historians now tell us that the right to which Blackstone referred, an important link in the Heller majority's historical argument, concerned the right of Parliament representing the people to form militia to oppose tyrant the king, threatening to deprive the people of their traditional liberties, which did not include unregulated right to possess guns. Thus, 18th century language referring to right to keep and bear arms does not ipso facto refer to private right of self-defense, certainly not unambiguously so. See English Historian's Brief 327, and see also Supra at 2.5. Third, Scully oracles indicate that firearms were heavily regulated at the time of the framing, perhaps more heavily regulated than the court in Heller believed. For example, one scholar writes that hundreds of individual statutes regulated the possession and use of guns in colonial and early national America. Churchill, gun regulation, the police power, and the right to keep arms, 25 Law and Hist. Everend 139, 143, 2007. Among these statutes was ban on the private firing of weapons in Boston, as well as comprehensive restrictions on similar conduct in Philadelphia and New York. See Acts and Laws of Massachusetts, p. 208, 1746, 5J. Mitchell, and H. Flanders Statutes at Large of Pennsylvania, from 1682 to 1801, pp. 108, 109, 1890. 4. Colonial Laws of New York, ch. 1233, p. 748, 1894. See also Churchill, Supra, at 162, 163, discussing bans on the shooting of guns in Pennsylvania and New York. Fourth, after the Constitution was adopted, several states continued to regulate firearms possession by, for example, adopting rules that would have prevented the carrying of loaded firearms in the city. Heller, 554 U.S. at Slip Op at 57 Bryer J. Dissenting. See also ID at Slip Op at 5960. Scholars have thus concluded that the primary Revolutionary era limitation on a state's police power to regulate guns appears to be only that regulations were aimed at legitimate public purpose and consistent with reason. Cornell, Early American Gun Regulation, and the Second Amendment, 25 Law and Hist. Everend 197, 198, 2007. The pre-Civil War 19th century. I would also augment the majority's account of this period as follows. First, additional states began to regulate the discharge of firearms in public places. C.E.G. Act of Feb. 1831 SS reprinted in 3 statutes of Ohio and the Northwestern Territory. 1740 S. Chase ed. 1835 Act of Dec. 3. 1825 ESSSS. 1825 10. Priv. Acts 306. Second, states began to regulate the possession of concealed weapons, which were both popular and dangerous. C.E.G. C. Kramer, Concealed Weapon Laws of the Early Republic, 143, 152, 1999, collecting examples. See also 1837, 1838, 10, Acts ch. 137, pp. 200, 201, banning the wearing, sale, or giving of Bowie knives. The 1847 Va. Acts ch. 7 ss. p. 110. Any free person who shall habitually carry about his person, hidden from common observation, any pistol, dirk, bowie knife, or weapon of the like kind, from the use of which the death of any person might probably ensue, shall for every offense be punished by fine not exceed $50. State courts repeatedly upheld the validity of such laws, finding that even when the state constitution granted right to bear arms, the legislature permitted to e.g. Abolish these small, inexpensive, most dangerous weapons entirely from use even in self-defense. Davy, State 3710, 496, 500, 1857. See also A. G. State v. Jumel 13 La, and 399, 400, 1858, upholding concealed weapon ban because it prohibited only particular mode of bearing arms which is found dangerous to the peace of society. State v. Chandler 5 La, and 489, 489, 490, 1850, upholding concealed weapon ban and describing the law as absolutely necessary to counteract vicious state of society growing out of the habit of carrying concealed weapons. State v. Read 1 La, 612, 616, 617, 1840. The post-Civil War 19th century. It is important to read the majority's account with the following considerations in mind. First, the court today properly declines to revisit our interpretation of the Privilege Immunities Clause. See ante at 10. The court's case for incorporation must thus rest on the conclusion that the right to bear arms is fundamental, but the very evidence that it advances in support of the conclusion that Reconstruction-era Americans strongly supported private self-defense right shows with equal force that Americans wanted African-American citizens to have the same rights to possess guns as did white citizens. Ante at 2233. Here, for example, is what Congress said when it enacted a 14th Amendment predecessor, the Second Freedmen's Bureau Act. It wrote that the statute, in order to secure the constitutional right to bear arms for all citizens, would assure that each citizen shall have full and equal benefit of all laws and proceedings concerning personal liberty, personal security, and the acquisition, enjoyment, and disposition of estate, real and personal, including constitutional right to bear arms by securing to all the citizens of every state or district without respect to race or color or previous condition of slavery. As 14 Stat. 176-177, emphasis added. This sounds like an anti-discrimination provision. See Rosenthal. The new originalism meets the 14th Amendment, original public meaning and the problem of incorporation. 18J. Contempt. Legal Issues 361, 383, 384, 2009, discussing evidence that the Freedmen's Bureau was focused discrimination. Another 14th Amendment predecessor, the Civil Rights Act of 1866, also took aim at discrimination. CSS 14 Stat. 27 citizens of every race and color without regard to any previous condition of slavery or involuntary servitude shall have the same right to engage in various activities and to full and equal benefit of all laws as is enjoyed by white citizens. And of course, the 14th Amendment itself insists that all states guarantee their citizens the equal protection of the laws. There's thus every reason to believe that a fundamental concern of the Reconstruction Congress was the eradication of discrimination, not the provision of new substantive right to bear arms free from reasonable state police power regulation. C.E. G. Brief for Municipal Respondents 6269, discussing congressional record evidence that Reconstruction Congress was concerned about discrimination. Indeed, why would those who wrote the 14th Amendment have wanted to give such a right to Southerners who had so recently waged war against the North and who continued to disarm and oppress recently freed African American citizens? Cf. Act of Mar. 2, 1867, SS 14 Stat. 487, disbanding Southern militias because they were inter alia disarming the freedmen. Second, firearms regulation in the later part of the 19th century was common. The majority is correct that the Freedmen's Bureau points to right to bear arms, and it stands to reason as the majority points out that it would have been nonsensical for Congress to guarantee the equal benefit of right that does not exist. Ante at 32, but the majority points to no evidence that there existed during this period fundamental right to bear arms for private self-defense immune to the reasonable exercise of the state police power. See Emberton, The Limits of Incorporation, Violence, Gun Rights, and Gun Regulation in the Reconstruction South, 17 Stan. L. and Polly Everin 615, 621, 622, 2006, noting that history shows that 19th century Americans were not opposed to the idea that the state should be able to control the use of firearms. To the contrary, in the latter half of the 19th century, a number of state constitutions adopted or amended after the Civil War explicitly recognized the legislature's general ability to limit the right to bear arms. See Tex. Const. R. ISS 1869, protecting the right to keep and bear arms under such regulations as the legislature may prescribe. Idaho Const. Art. ISS 1889, the people have the right to bear arms, but the legislature shall regulate the exercise of this right by law. Utah Const. Art. ISS 1896 same. And numerous other state constitutional provisions adopted during this period explicitly granted the legislature various types of regulatory power over firearms. See brief for 34 professional historians et al. As Amici Curie 1415 hereinafter legal historians brief. Moreover, 4 states largely banned the possession of all non-military handguns during this period. See 7910. Pub. Act ch. 186 SS prohibiting citizens from carrying, publicly or privately, any belt or pocket pistol, revolver, or any kind of pistol except the Army or Navy pistol usually used in warfare, which shall be carried openly in the hand. 1876 Wyo. Comp. Law ch. 52 SS forbidding, concealed or open, and bearing of any firearm or other deadly weapon within the limits of any town or village. Arc. Act of Appra. 1. 1881, ch. 96 SS prohibiting the wearing or carry ng of any pistol except such pistols as are used in the Army or Navy, except while traveling or at home attacks. Act of Appra, 12, 1871, ch. 34 prohibiting the carrying of pistols unless there are the immediate and pressing reasonable grounds to fear immediate and pressing attacker. For militia service, 15 states banned the concealed carry of pistols and other deadly weapons. See Legal Historians Brief 16 N. 14. And individual municipalities enacted stringent gun controls, often in response to local conditions. Dodge, Kansas, for example, joined many western cattle towns in banning the carrying of pistols and other dangerous weapons in response to violence accompanying western cattle drives. See Brief for Municipal Respondents 30 citing Dodge City Can. Ordinance No. 16 SSISUP 22, 1876 D. Courtright, The Cowboy Subculture and Guns in America. Reader 96 J. Dizzard et al. eds. 1999, discussing how western cattle towns required cowboys to check their guns upon entering town. Further, much as they had during the period before the Civil War, state courts routinely upheld such restrictions. C. E. G. English v. State 35 Tex. 473, 1871 Hell v. State 53 Ga. 472, 475, 1874 5 v. State 31 Arc. 455, 461, 1876 of State v. Workman 35 W. VAT 367, 373, 1891. The Tennessee Supreme Court, upholding ban on possession of non-military handguns and certain other weapons, summarized the Reconstruction understanding of the state's police power to regulate firearms, admitting the right of self-defense in its broadest sense. Still, on sound principle, every good citizen is bound to yield his preference as to the means to be used to the demands of the public good, and where certain weapons are forbidden to be kept or used by the law of the land in order to prevention of crime great public, and no man can be permitted to disregard this general end and demand of the community the right, in order to gratify his whim or willful desire to use particular weapon in his particular self-defense. The law allows ample means of self-defense, without the use of the weapons which we have held may be rightfully prescribed by this statute, the object being to banish these weapons from the community by an absolute prohibition. For the prevention of crime, no man's particular safety, if such case could exist, ought to be allowed to defeat this end. Andrews v. State 5010. 165, 188, 189, 1871. Emphasis added. The 20th and 21st centuries, although the majority does not discuss 20th or 21st century evidence concerning the Second Amendment at any length, I think that it is essential to consider the recent history of the right to bear arms for private self-defense when considering whether the right is fundamental. To that end, many states now provide state constitutional protection for an individual's right to keep and bear arms. See Volok's Constitutional Rights to Keep and Bear Arms, 11 Tex. Everand L. and Paul. 191, 205, 2006, identifying over 40 states. In determining the importance of this fact, we should keep the following considerations in mind. First, by the end of the 20th century, in every state and many local communities, highly detailed and complicated regulatory schemes govern and continue to govern nearly every aspect of firearm ownership: who may sell guns, how they must be sold, who may purchase guns, and what type of guns may be purchased, how firearms must be stored and where they may be used, and so on. See Generally Legal Community Against Violence, Regulating Guns in America 2008, available at http://www.alcav.org/publications. Briefs Regulating Guns. ASP All Internet Materials is visited June 24, 2010, and available in Clerk of Court's case file detailing various arms regulations in every state. Of particular relevance here, some municipalities ban handguns even in states that constitutionally protect the right to bear arms. See Chicago, Ill. Municipal Code SS 2050C 2009, Oak Park, Ill. Municipal Code SSS 2127 1995, Toledo, Ohio. Municipal Code CH 549.25 2010. Moreover, at least 7 states in Puerto Rico ban assault weapons or semi-automatic weapons. See Cal. Penal Code Ann. SSB. West Sup. 2009 Acon. Enrollstat N. SS 200 TWAC 2007. AHA. Everenstat. SS 8 1993 M. Crim. Law Code Ann. SS 303 Date Lexus 2002 Mass. Enroll Law CH 140 SSM West 2006 NJ Stat N. SS 395 West Sup 2010 NY. Penal Law N. SS.27 West Sup 2008 25 Laws P. R. N. SSM Sup 2006 See also 18 U. SC. SSO Federal Machine Gun Ban 13 municipalities do the same. See Albany, N.Y. City Code SS 16A 2005 Aurora, L. Code of Ordinances SS 49A 2009 Buffalo, N.Y. City Code SS 1 F 2000 Chicago, Ill. Municipal Code SS 2425A 2010 Cincinnati, Ohio. Municipal Code SS 37A 2000 Cleveland, Ohio. Codified Ordinances SS.3A 2008 Columbus, Ohio. City Code SS.31 2007 Denver, Colo. Municipal Code SS 130E 2008 Morton Groveville. Village Code SS 23 NYC. Admin Code SS 303.1 2009 Oak Park Hill. Village Code SS 21 2009 Rochester, NY. City Code SS 5 F 2008 Toledo, Ohio. Municipal Code SS.23 and 2 states, Maryland and Hawaii, ban assault pistols. See Hall. Everenstat and SS 8 Crime Law Code and SS 303 Lexus 2002. Second, as I stated earlier, state courts in states with constitutions that provide gun rights have almost uniformly interpreted those rights as providing protection only against unreasonable regulation of guns. C. E. G. Winkler scrutinizing 686. The courts of every state to consider gun regulation apply the reasonable regulation approach of State v. The Cadams 714 p. Twad 1236 1238 Wyo. 1986 The Robertson v. City and County of Denver 874 p. Twad 325 328 Colo. 1994. When determining reasonableness, those courts have normally adopted highly deferential attitude towards legislative determinations. See Winkler scrutinizing 723, identifying only 6 cases in the 60 years before the article's publication striking down gun control laws. 3 that ban the transportation of any firearms for any purpose whatsoever, single permitting law, and 2 as applied challenges in unusual circumstances. Hence, as evidenced by the breadth of existing regulations, states and local governments maintain flexibility to regulate firearms much as they seemingly have throughout the nation's history, even in those states with an arms right in their constitutions. Although one scholar implies that state courts are less willing to permit total gun prohibitions, see Volokh, Implementing the Right to Keep and Bear Arms for Self-Defense. An Analytical Framework and Research Agenda 56 ULL, Everin 1443, 1458, 2009. I am aware of no instances in the past 50 years in which state court has struck down as unconstitutional law banning particular class of firearms. See Winkler scrutinizing 723. Indeed, state courts have specifically upheld as constitutional under their state constitutions firearms regulations that have included handgun bans. See Caladimos v. Village of Morton Grove, 103 ill. Twad 483, 499, 470 n. E. Twad 266, 273, 1984 upholding handgun ban because the arms right is merely right to possess some form of weapon suitable for self-defense or recreation. A Cleveland v. Turner No. 36126 1970 Civ Bull L 201393 star 5 Ohio CT App OG 4 1977 handgun ban does not absolutely interfere with the right of the people to bear arms, but rather prescribes possession of specifically defined category of handguns. A State v. Ballin 378 SC 9699 662 SE FWAD 3839 2008 ban on handgun possession by persons under 21 did not infringe arms right because they can possess other types of guns. Thus, the majority's decision to incorporate the private self-defense right recognized in Heller threatens to alter state regulatory regimes, at least as they pertain to handguns. Third of the plurality correctly points out that only few state courts, paucity of courts, have specifically upheld handgun bans, ante at 39. But which state courts have struck them down? The absence of supporting information does not help the majority find support. Cf. United States v. Wells 519. S. 482, 496, 1997, noting that it is treacherous to find in congressional silence alone the adoption of controlling rule of law, internal quotation marks omitted. Silence does not show or tend to show consensus that private self-defense right strong enough to strike down handgun ban is deeply rooted in this nation's history and tradition. In sum, the framers did not write the Second Amendment in order to protect private right of armed self-defense. There has been and is no consensus that the right is or was fundamental. No broader constitutional interest or principle supports legal treatment of that right as fundamental. To the contrary, broader constitutional concerns of an institutional nature argue strongly against that treatment. Moreover, nothing in 18th, 19th, 20th, or 21st century history shows consensus that the private armed self-defense as described in Heller is deeply rooted in this nation's history or tradition, or is otherwise so fundamental. Indeed, incorporating the right recognized in Heller may change the law in many of the 50 states. Read in the majority's favor. The historical evidence is at most ambiguous, and in the absence of any other support for its conclusion, ambiguous history cannot show that the 14th Amendment incorporates private right of self-defense against the states. With respect, I dissent.